How does legal capacity impact elder law POA revocation? Have you ever wondered how a person's mental ability affects their decisions in elder law, especially when it comes to revoking a power of attorney? Understanding this can make a big difference in estate planning and future directives. Legal capacity refers to the mental ability to understand and appreciate the nature and consequences of legal actions. In elder law, this capacity is essential for creating, managing, and revoking a power of attorney. A power of attorney is a legal document that allows someone, known as the principal, to appoint another person, called the agent or attorney in fact, to make decisions on their behalf. These decisions often involve financial matters or health care. To validly revoke a power of attorney, the principal must have the legal capacity to understand that they are ending the authority previously granted to their agent. If the principal lacks this capacity at the time of revocation, the revocation may not hold up legally. This is because revoking a power of attorney is a legal act that requires the principal to comprehend the implications of removing the agent's authority. Legal capacity is not a constant state. It can change based on the complexity of the decision and the individual's condition at that moment. For instance, a person may have the capacity to revoke a power of attorney one day but not the next. This is especially true for elderly individuals who may experience fluctuations in cognitive function due to conditions like dementia or other mental impairments. Since legal capacity is specific to the task at hand, a person might be able to make some decisions while struggling with others. Courts typically evaluate capacity based on the specific action involved, which in this case is revoking a power of attorney. If there is uncertainty about a person's capacity, medical evaluations and legal assessments may be necessary to determine if the revocation is valid. From a practical standpoint in elder law, it is important to ensure that powers of attorney are executed when the principal clearly has capacity. This helps avoid disputes later on. Including provisions in the power of attorney document about how and when it can be revoked is also wise. For example, you might requiring written notice or specify conditions for automatic termination. Once a principal is legally incapacitated, revoking a power of attorney may requiring court intervention. This could involve guardianship or conservatorship proceedings to protect the principal's interests. It is also advisable for clients to communicate clearly and document their intentions regarding revocation to prevent misunderstandings or challenges. In summary, legal capacity directly impacts the ability to revoke a power of attorney in elder law. Without sufficient capacity, a principal cannot effectively revoke a power of attorney, which may lead to the need for legal processes to ensure decisions align with their wishes. Understanding this connection is key for anyone involved in estate planning and future directives.